and starting this first panel of today's conference. So we're going to focus, obviously, on AI and the regulation of AI and what it means for innovations and competition with different related topics. So there's been a lot of discussions on AI, starting from the antitrust authorities, but also different agencies. One theme that perhaps has been in the mind of potentially the antitrust authorities when it comes to AI was starting with these investments that we've seen very recently by a number of companies, large companies, in those very innovative companies. So perhaps we can start with this, and because there's some fears. Are they overblown fears, or are there real concerns that these investments may be the next way of, we talked about monopolizing the AI sector, or is it just like overblown fears? Perhaps, Adam, do you want to kick out on what are those investments? What are those mergers, if there are mergers at all, and what does it mean for competition?
Sure. Well, thanks, Aurélien, and thank you to GW and to Cornerstone for putting on this terrific program. I'm privileged to be a part of it. Just to set the stage here and invite others to comment and to bring everyone up to date on where mergers, partnerships, and transactions are with respect to AI. So stepping back, none of us, literally none of us would be here without partnerships and joint ventures. And I mean that because whether you came in on a train or drove here or flew in, at some point in history there was a collaboration, probably many collaborations, to bring that technology to commercialization and use. And what I do on a daily basis as an M&A focused antitrust lawyer is also advise clients on partnerships and things that are not a full-on merger or an acquisition where two independent companies become one. And these are incredibly common, and there's a long history and practice within the law on how to address them. And we often call these joint ventures, where you have two companies coming together usually with complementary technologies and resources to create something new and different. So what's new and different about AI and joint ventures? Well, if we go back in history, maybe 20 years, 30 years, and we examine the remarks of many of the enforcers, both here in the United States and abroad, there's a feeling that with the development of internet-based technologies and telecommunications, there was, and this is not my view, but this is the view expressed by leaderships of both the Antitrust Division and the FTC, that there was a missed opportunity to more carefully scrutinize mergers, acquisitions, partnerships, and joint ventures in the tech space. Now we see generative AI emerging as a new and exciting technology. We just heard that in our thoughtful opening remarks. And what the agencies have done in the United States and abroad is decided to intervene, and I use that term very loosely, in ways that we haven't really ever seen before in the tech space. And by intervene, I mean the FTC has opened up a 6B study under its 6B authority under the FTC Act. We see conferences, we see blue ribbon panels, and we see investigations abroad, such as the investigation by the CMA of Microsoft Inflection, which was of a partnership, not a merger, involving the acqui-hire of certain Inflection employees and licenses. So I will give you a 30-second synopsis of what the legal process and substance is in this area. Process-wise, we think of, do you have to notify your partnership to the DOJ and FTC ahead of time and give the DOJ and FTC an opportunity to weigh in? That's what HSR is about. There are many analog laws around the world. Generally speaking, a minority interest, the purchase of minority interest by a larger company and a smaller company, in many cases is not reportable if it's what we call a non-corporate entity like an LLC, which is very common in the tech space. Non-exclusive licenses are not reportable under HSR. So in those instances, the government traditionally doesn't have an opportunity to preview and pre-investigate a partnership. However, on the substance, the government always has the ability to go back. We have Section 7 of the Clayton Act, we have Section 1 of the Sherman Act, Section 5 of the FTC Act. All of those are generally speaking backward-looking, or can be backward-looking, and substantive violations, the lessening of competition can be studied. And so where we are today is that the agencies have decided that AI and the growth of AI needs to be studied in ways that we haven't seen before this early in the development of an industry. Typically, as antitrust lawyers, we think about relevant markets. What is the harm in the relevant market? We rarely think about what is the harm when there is no market. And I think generative AI, you can make out markets. There are certainly firms that operate in this space, but we don't know what the market is. We don't know what the end use is. We just have ideas of the benefits it could have. And that's where we start out this discussion, I think. And I'll just pause there.
Thanks so much. Amba, do you want to react on what are those investments, partnerships? Some are to bring capabilities for those precisely those very early startups or small companies to deploy AI. But so what is your take on the regulatory worry about those investments?
Sure. I'll say that while I agree that there has been a lot of activity in the UK, the European Commission, and the FTC's 6B study, and maybe you alluded to this too, I think describing these as interventions would maybe go a step further than I would, because I think the dynamic we've seen in response to this blitz of unconventional business arrangements, maybe to your point, sometimes conventional, but the way in which these agreements have been structured, there seems to be something novel about it. And I think in response to the blitz in this new kind of arrangement, what we've seen across the board, with the exception of the 6B study, because that's still in some ways TBD, is the response that there's sort of nothing to see here, that on a plain reading of the law, these arrangements don't, they might activate a smell test, but they don't go any further than that. And so, and I think it's worth saying here, I might be in a small minority here. Our research organization does not have any corporate clients, and we do not accept corporate funding as well. And so the positions that we put out in our policy recommendations, what we've been sort of arguing for is that maybe the question of whether OpenAI is a Microsoft puppet, or whether Anthropic and Amazon meet the turnover threshold in the UK, or whether Inflection and Microsoft cease to be distinct entities. Sure, those might be the questions that are legible to the law, but we think that those might actually be a distraction from a much more fundamental question, even if less legible to the law, which is a very concerning concentration of power that we're seeing only getting exacerbated in the AI market. And General Akasona sort of alluded to this in a different context earlier, which is that I think at the start of 2023, there was a lot of exuberance around the innovative and disruptive potential of this AI market, and the potential for new entities and sort of new Silicon Valley leaders at the helm of this new revolution. But cut to this moment, and Sequoia's recent report sort of almost counts the last men standing in this market, and it's very much the grouping. It is notable because it's sort of Microsoft, OpenAI, Amazon, Anthropic as sort of combined, and then Meta, xAI, and Google, right? And so I think what's important to note here is that in a market where scale and model size in particular has become the proxy for advancement and for performance, what is very clear is that those that control access to computing infrastructure and distribution networks are in a position to be kingmakers. And that is what we're seeing play out time and again. So even as we're seeing reports of tensions, and this is from last week, in the kind of Microsoft OpenAI arrangement around compute, what's very clear is that relationship of dependency in an environment of scarcity absolutely does exist. Whether it's a merger or not maybe is even besides the point. And I think in this next phase, what the AI market lacks or may lack in a kind of viable long-term business model, this is my opinion, at this point, it is making up for in this promise that we are on the precipice of AGI, right? Artificial general intelligence, that there is a leap. We don't know if it's tomorrow. We don't know if it's 10 years. Maybe you can tell me. But sort of, the idea is that is the sort of next inflection point. And what will get us there, much, much more computing power, much, much more capital expenditure, much, much more, as we just heard, data center build out. And so I think, again, the question that's keeping us up at night as sort of, policy, as a policy research institute looking at this market is that, what does it mean for innovation if the inputs in this market are defined by these choke points at every layer, and when the sort of barrier to entry seems to be at sort of every single layer of the AI stack?
I mean, can I just build on that? Because, I mean, Amba raises like a number of interesting points. But I think it's, I don't think we should be surprised that the large tech players are trying to have a significant presence in what might be the most important new digital-based technology. It's natural to expect any large tech company that sort of has a multi-billion-dollar revenue stream to sort of come up with some way to enter it, whether it's like Google by developing it itself, Microsoft through partnerships, Amazon through investments. But I think another interesting inversion that's being pointed to here, if you compare it with the PC era, is the hardware-software inversion, right? And what I mean by that is, as PCs emerged, I mean, IBM was the initial innovator. But then the hardware, by and large, got commoditized, and the value capture started to center around the software, the operating system. Microsoft became the most important, most valuable company in the world. I don't think there's any debate that from an end user point of view, generative AI has created value, created entertainment, created a tremendous amount of excitement. But the inversion that I'm talking about is from a value capture point of view. I mean, the most valuable AI connected company in the world is a hardware company, as a chip manufacturer. The value capture from the use of AI is largely concentrated right now in the semiconductor and cloud infrastructure realm, right? I mean, OpenAI by its own, sort of numbers is still sort of cash flow negative, and so that's, that's clear. So, in thinking about, these partnerships, all of them seem to have three components, right? I mean, there's the language model or the generative AI, the model itself. There's the computing infrastructure, and then there's the application environment. And a new innovator in AI, in sort of creating a new model, especially someone who is small and sort of the innovative startup, is unlikely to be able to bring an established application environment or an established multi-billion-dollar infrastructure. They're likely to be able to bring a new model, but it's natural for them to seek partnerships to sort of get the other two pieces into place. And it happens to be that we've got Google with its application environment and its infrastructure, Microsoft with sort of the desktop Copilot application environment and its infrastructure, and Amazon with its sort of retail and video application environment and infrastructure. So I feel like this is just sort of a natural consequence of the underlying economics of sort of what we're seeing emerging in the generative AI space.
I would just jump in on that. Well, first of all, unlike Amba's, my law firm is very much funded by corporate donations. So I'm not going to comment on any of the particular collaborations that are in play. But I mean, I will say this, which I think it's interesting to talk about collaboration after General Nakasone's keynote, right? Because I think there's a constant discussion, and rightly so, about the externalities, being created or that people think might be created, as well as, the challenges and opportunities of these technologies, which I think it's a broad spectrum of them, and it's important to be precise about which ones we're talking about. But at a general level, right, I think that keynote shows you that those externalities and sort of the success of this technology in a way that has broad benefits while mitigating the costs is something that has to be done collectively in some way. Now, whether the particular collaborations going on now, meet that goal or not, I'm not going to comment on that. I think there's people trying to figure that out. But I think it is interesting that the challenges, and I think some of the critics in this space are vocal about those challenges. I think they're challenges that have to be met collectively. And I think it's interesting to contrast that to this sort of retrospective view from, where I usually sit from litigation. One of the things I think we're hearing now from enforcers is, well, we've been too retrospective. We have to get involved early. But if you look at the ways that the criticisms of big tech in the retrospective litigation that's going on now, it's not complaints really about collaboration. It's complaints about sort of independent hyper competition. And the criticism is, well, when we let individual companies kind of do things on their own, unfettered, we created all these externalities. So I think it's interesting to sort of say, well, there were externalities when companies became sort of hyper competitive independently, and now there's concerns about externalities with collaboration. I'm not sure you necessarily can always have it both ways. And I think it's just important as we go forward to think about whether there are challenges in this space that can only be met collectively, security, maybe privacy, IP, otherwise. Again, I don't have a particular solution to any of those things in mind or a particular collaboration in mind, but I think it's probably something that has to be on the table.
Katrina, I would love to have your point, of course, of what you heard, and to feel free to react. But also, so we talk about those partnerships and the closeness that it can bring. There's another debate that I would like to mention in terms of regulations of AI is the discussion about closed source, open source, and what potential risks that are associated with open source. First, what is open source AI or whatever, and also what are the risks that you see in both type of models, but also feel free to react on what you heard.
So I'm Katrina Mulligan. I lead national security at OpenAI, and I come at this problem set and conversation from a pretty different perspective than some of the other panelists, because I am primarily focused in understanding AI as a tool for national competitiveness from a national security angle. Obviously, the economic competitiveness piece is really important to the company as well. And I guess I have a couple of responses. One is that it is true that infrastructure is destiny in this space, and I think there's there's a lot of good points that have been made. The one point I would add that we haven't talked about is actually that the United States, I think, has done the most that it's going to do in terms of investing in infrastructure on behalf of sort of the American economy, and what we got out of that was $56 billion, if my memory serves, which is, in my estimation, a fraction of the amount that would be needed to scale up to the level that I think AI is going to need to scale up. And so what that means, and $56 billion is not a small amount of money, right? But what it means is that we are in the universe of nation state actors being the ones really who are going to finance the future of this technology. And the United States has done the most it's already going to do, and it's not enough. And other nation states are prepared to pony up significantly more than the United States has been willing to. And I think that raises some really interesting geopolitical questions about the moment that we are in. And to be honest with you, I think if the United States weren't quite reasonably distracted with some very important and serious national security concerns that are happening in the world today, I would want them to be focused on this question, and I want them to be focused on it more than they are now, because it isn't today's problem, but it is absolutely going to be tomorrow's. And so that's one intervention that's hopefully useful. So open source versus closed source, just to kind of level set everybody's understanding, there is a belief in the community, a belief that is shared by many in the tech industry, that there is something inherently important for competition about having model weights be available publicly and freely to anybody who wants to use them. The challenge with that, there are benefits, and you can think off the top of your head of what some of them are. The challenge is that in a world in which the United States it's been the policy of the United States to try to constrain the proliferation of this technology, particularly in China, through export controls and other things, the availability of open source models really kind of undercuts those efforts to some degree. It is also deeply political inside, so I'll be totally transparent with the audience. It is a political and sort of controversial topic, because on the one hand, there is a sense that we want to democratize AI. Companies like OpenAI, whose missions are to benefit all of humanity, have a deeply held view that the end state that we want isn't one in which a very small number of people control this technology. In our entire board structure, and as quirky as it is, was designed to try to address that to some degree with varying degrees of success. And so it is also the case that this IP is incredibly valuable and incredibly expensive to produce. And so, in my opinion, incredibly important for the national security of the United States and like-minded countries. And so there's this debate about whether OpenAI, whether open sourcing these models is a good thing or a bad thing. And I won't wade into that too deeply, because I honestly think a lot of people who've been thinking about this a lot longer than me have said and written all that they're, arguments on both sides. And they're, what's most compelling to you, I think, it depends on where you sit in this debate. But what I will say is that the national security and economic competitiveness questions that underpin this are going to be, one of the reasons I'm at OpenAI, it's my first time being in the private sector, 20 years in the national security world, is that I genuinely believe that the most important national security questions that we will face in the next 5 to 10 years will be made in the private sector and answered in the private sector, and I wanted to be a part of that. And I think, the challenge that I face right now is getting the government and government stakeholders who are quite reasonably focused elsewhere to be like, hey, over here, major important thing is happening. And our window to influence the outcomes and the window that I think where we're going to maintain the leading edge on this technology is finite and not a guarantee for the future. The last thing I'll say is that I really think that watching what has played out in Europe and elsewhere around the issues of competitiveness and regulation and the balance between the two has been really instructive. One of the things that I see coming down the pike that ought to give people a little bit of comfort maybe in this space is that I think we thought in the beginning of the kind of race to AI. OpenAI was the company that discovered the scaling laws and the first to discover that by adding more data and more compute, you could get better outputs from these models, and that has largely been the sort of underpinning of the way that the industry has developed to date. What I would say with the release of our newest model, the O1 model, the reasoning model that came out 3 or 4 weeks ago, is that it really kind of turned some of our assumptions on their head. So for those of you who aren't following this every day, day in and day out, the O1 model is our first, we view it as, the first level of AI development of capability levels was really the chatbot era. And everything up until the release of O1 was really level 1. what we think with the release of the O1 model is that we have moved into reasoning, which is a different way. It's a different technique. This is not a newer, different model. It's not a bigger model. It doesn't have more flops and more data. It is a technique that you can apply to any model that allows the model to think longer before answering a question, and it actually gets you far better results, dramatically better results. And it hallucinates much less, and it basically upends one of our core beliefs about scaling, that the only way to get better performance is to have more compute and more data. And what we are finding is that you can actually get much better, significantly better performance with less compute, and that changes the game a little bit. And so, do I still think that compute, I said, and I believe infrastructure is destiny, that will continue to be powerfully important. But what it means is that new players are going to be able to enter the space, and you're going to see, my prediction, you're going to see, and you already have seen, people leave some of the bigger AI companies. And if you think about why that's happening, some of the reason that's happening is because they're realizing that it's not just going to be, AGI isn't going to be one system. It's going to be a system of systems. And that's kind of a new, when 2 years ago, everybody was coming, just flocking to the big AI companies because they were like, if I don't have all the compute and all the data and all the resources, I can't make anything compelling in this space. But you're actually, I think, starting to see and going to see more people breaking off to build their piece of the AI puzzle. And I think that actually gets at what some of the other speakers are saying, we would want to see and aren't seeing yet. I would say, stay tuned. It's beginning now.
Can I just build on that? Because I mean, you covered such a broad spectrum.
Yeah, sorry about that.
Of topics that I agree with you completely. That I think that this is going to continue to be an infrastructure game, not necessarily because large language models are going to get bigger, but because the number of things that we embed generative AI into is going to grow dramatically, thereby requiring more compute power. And we're going to enter a world in which, some people have been following the world models realm, in which we're trying to sort of generate, what will physical space look like in 2 seconds if it looks like this now, which could be the future of self-driving cars. Those are sort of far more computationally intensive than the language models because, physical space is far more complex than the written word. But I think on the open source topic, there's if you're an industrial organization economist, you can imagine a game theoretic model in which you have 3 companies competing for tech leadership in a particular sector. And they have 2 strategies. One is a closed system and the other is an open system. And you can imagine an equilibrium emerging where if you're not the leader, then open sourcing to grow your ecosystem becomes a much more viable strategy for eventual market dominance, assuming that there is a belief that applications that are going to be developed around this core technology are specific to the particular sort of model that you're building. I think one of the most interesting developments or changes for me between, I guess, early 2023 and mid 2024 was the shift that I started to see in companies away from creating sort of company-specific or application-specific generative AI that involved directly changing, the parameters of the model, fine-tuning it, and towards an approach where you were sort of building your own semantic search and other capabilities, and sort of using retrieval augmentation to take advantage of the large language models. And so you were lowering the dependence that you had on a particular large language model or a particular generative AI system by separating out what is specific to your company and what are the generic sort of common sense and grammar capabilities that you're going to sort of extract from the more general sort of large language model. And so that sort of is taking us more and more into a world, and just to sort of reiterate the hardware software inversion, to a world where it's more and more likely that like the way that we use these generative AI systems may be less and less specific to a particular large language model, which means that the competitive dynamics are less likely to sort of go down the path of being winner take all, and more likely to go down the path of we're going to have not just sort of like the big tech companies with their big large language models, but small language models and other things. And just sort of one final comment on what Katrina said about reasoning. I mean, a number of us in academia have been doing research on how does the output of a generative AI system change when you imbue it with certain, or you instruct it to reason in a particular way. Mm-hmm. There's been like chain of thought reasoning, tree of thought reasoning, a whole bunch of other sort of reasoning techniques that can dramatically change the capabilities. And I think again this while on the one hand this is likely to take us in a direction where the performance dependence on having the latest model with the most infrastructure is lower, because you can get more out of it by imbuing it with certain reasoning capabilities. I'm pretty confident that that's going to be countered by just sort of the dramatic expansion of the set of things in which we are reliant on generative AI. I mean, and there's sort of a huge cost dimension to this. I'm trying to remember which company this was. I think it was Canva that raised its subscription fees by 300% recently, because just the underlying cost structure associated with delivering a software product has now sort of gone up so dramatically. So I feel like there's in sort of thinking about sort of the competitive dynamics of this industry, looking at the layer of models exclusively, rather than thinking about that this is a technology with a fundamentally different kind of production cost structure relative to sort of the software industries that have preceded it, might be sort of a good shift.
Well, I think, but what's interesting about this discussion, I think, is and I don't mean to criticize the panelists for imprecision. I think it's endemic to the sort of whole discussion is sort of a level of imprecision about what products are we talking about. Sort of to Adam's point earlier, we can identify companies that play in this space, but the notion of what the product is and what the market is, I think, is quite uncertain still. In part because we don't fully know what all these things are going to be used for. That's kind of the exciting part, but also I think maybe gives rise to some of the concern. And I think there's an imprecision about this sort of open-closed dynamic as well, right? These, in a number of respects, these things are treated sort of as binaries, right? There's open and closed, and I think the reality is that it's very much a spectrum. That it's what exactly are we saying is going to be open. I think certain things might be comfortable from a security perspective to be open, whereas other things is very different to open what those things are. And I think the reason that I think the imprecision matters is maybe where Arun ended, which is the notion of this of closed being quote unquote closed. Again, what do people mean by that exactly? And is it closed in a sense that actually has a commercial effect, or is it closed only in a sense of that we're actually advancing national security goals? But if you think that closed is a problem, I think implicit in the kind of closed criticism is this idea of lock-in, right? That somehow we're on the way to creating ecosystems that are where there's a platform in order to get your product off the ground, you need to use a particular model or be tied into a particular infrastructure. And I'm not sure that we're there yet, given the number of players in the space and the way that the competition seems pretty intense kind of between these players. And so I think it's important to kind of unpack that implicit assumption that that dynamic is going to be there, because again, unless you're being precise about the product you're talking about or the application that you're talking about or the platform dynamic, whatever you may say that is. And I told Brian I wouldn't steal all of the things from his next panel, so I won't go into that too much. But I think in order to get to, I think, a useful place in the discussion, I think it's really important to be precise about what we mean by AI, what product we're talking about, and what precisely do we mean is open versus closed, because I think that can take us to a number of different
I'm talking about model weights.
Right.
So when I talk about open versus closed, I'm talking about the actual model weights. I mean, one of the things that is so surprising about AI to me, as somebody who's, I'm not an AI expert, although I've come to realize that I actually know more about AI than like 99.9% of the, world's public right now, which is because the bar is so low. But I don't come at this from an AI background, and what surprises me greatly is how much what is truly valuable knowledge in our companies is a file of numbers. The most valuable secret sauce at OpenAI is like a file that you could put on a thumb drive, and secrets that you can say in a sentence. So I'll tell you one of them because it's not a secret anymore. One of them was just the Moore's law that if you apply more compute and more data, you get better outcomes. That was a massive breakthrough. We just published it, told everybody. We now have other breakthroughs that we are having in our company and other companies that are things that are just as simple to understand that are the secret sauce, and so it makes these questions about what we're gonna open source or what we're gonna just put out there versus what the real value of the company is. It makes these questions really important. And the other thing I would say is it's I spent my whole career having no idea what it would feel like to work in a company with a profit motive, because I work for the American people, and turns out you're never going to get rich doing that. I know because I did it for 20 years.
OpenAI is a non-profit, right?
Yeah. No, well, OpenAI is a capped profit structure today, but working at a company where you are making these trade-offs and everything you do is kind of it's very zero sum, and you're thinking about these things. It changes. I work in the company. I'm trying to get them to sort of think about the national security world and partnerships with government. And, it's a tough sell in an AI company right now to say we should take 12 to 20 of zero-sum engineers who are some of the most highly coveted talent in the world and put them in a room to do nothing but FedRAMP for a year. When they could be doing all these other things for the company because we want to, sell ChatGPT to the government. Turns out that's a tough sell. And so, we have to, I think, grapple with some of those incentives and dynamics as well.
That's very interesting. That's neat.
I know you want to move on, but there's a few things I want to respond to. And actually what Katrina said is maybe the most interesting one, which is, I think, you started off by defining open source AI as open model weights, and I was sort of okay, fine, there is that sort of there's welcome precision there. It seems like the NIST consultation also, or the NTIA consultation also kind of defined open source AI in that specific way. But I think if we zoom out, there's actually been a pretty heated discussion in the broader open source technical community around definitions when it comes to open source and open source AI. And it started with the idea that there's sort of a normative force with sort of claiming that your approach is open, right? It is equated with innovation. It is equated with competitiveness, and that comes from sort of the legacy of the open source movement when it comes to software. And there was a way in which Meta in particular, and I'll name them because I think they've probably benefited the most from that normative force, was able to, as well as other kind of trade organizations, use that to, in many conversations, some of which I have been in personally, undercut arguments for more structural competition intervention in the market. That if it was only all open source AI, then or open AI and open model weights, then we wouldn't need additional competitive regulatory intervention. So I think positioning openness and open source AI, whatever that means, as a silver bullet to competitive constraints, is something that we've been, trying to debunk in various ways, including in sort of like drawing out the stack and arguing that choke points exist across the stack. And the conversation we've been having on more compute efficient methods for training, I think still obscures the fact that if you're going to run inference at scale, if you're going to have a product that people are using, to your point on Canva, that you are going to, there is still going to be a pretty high barrier to entry when it comes to compute costs. So I think the first is like, openness has become a little bit of an eyewash, and one that has been leveraged very effectively by industry lobbyists. And then the only other thing to say is that outside of the context of sort of competition enforcement, we saw in the EU around the AI Act that there was I'm forgetting the name of the trade group, but there was a large trade group that argued that any kind of regulation on foundation models would clamp down on open source innovation. And there were big tech companies, there were smaller providers in this trade group. And so it is in that context, sort of responding to that we sort of went back to the basics. And our recommendation to policymakers was that what the EU AI Act is, at least in principle, trying to do is introduce transparency at various levels of the AI stack. Arguably, open source or truly companies that are committed to openness should be more on that side of the spectrum than less. And I think this comes back to the fact that companies like Eleuther that are open source AI projects would argue that, yes, open model weights is where some of the secret sauce competitive benefit is, but it is also true that exists in the data sets. And that doesn't mean all data sets obviously have to be open, but it is true that having more information about what training data is being used is as much part of the secret sauce as the model weights themselves, or certainly that is part of the puzzle. And I think that's another place where I think drawing certain fault lines around what is and isn't open is important when you're trying to then assess to what extent that contributes to like pro-competitive
But I
dynamics.
think that it's also useful to sort of lay down what the objectives of openness are.
Right.
Because I'm not agreeing or disagreeing with the idea that training data should be transparent, and we may get to training data and intellectual property at some point later. But I recognize the national security issue of the trade-off between open and closed. But I think the real sort of societal value-adding innovation around artificial intelligence isn't going to stop with the creation of the models themselves, right? I mean, it's going to sort of be on sort of the applications and the uses that we build of these foundation models. And the barrier to entry there, I mean, clearly there is sort of a cost barrier to entry, clearly there is an infrastructure cost. But I think it's important to distinguish between, to not think of it as some sort of incredibly high, I have to build a power plant, I have to sort of set up the telecommunications network across the country kind of barrier to entry cost. Because a lot of the price increases that we're seeing are much more variable cost increases, not fixed cost increases. I mean, when people say that a Google search that is AI-powered costs more than a Google search that isn't, I mean, they're talking about a variable cost here. And this isn't a barrier to...
as much, apparently, in terms of energy costs.
True, but it's not a barrier to entry in sort of a competitive sense, right? I mean, it's a barrier to entry in terms of you've got to come up with a decent business model that can, charge the customer enough of a price to sort of justify the compute power that you're using. And I think that's a very important distinction in thinking about, sort of what is the competitive landscape around AI going to look like, and as it's connected to the infrastructure costs. Yeah.
I would like to move the conversation for what we talk about these barriers to entry.
That's your role. Our role is to sort of keep talking.
We can keep talking about these themes, particularly but there's so many aspect implications about AI regulations. One thing is once you build the AI and particularly the algorithm, there's this concern, or at least from regulatory perspective, that this algorithm can collude and can conspire, and they can lead to commercial output where there's like a stability. We've seen that over the last few years, even before the advent of AI and ChatGPT, this discussion about algorithm. Perhaps, Adam, do you want to talk about what are those fears as well from a regulatory perspective about algorithmic collusion and the potential for conspiracy around the technological basis?
Sure. So this is a big issue in antitrust, and I would venture to say it's probably one of the top 2 or 3 issues, is the extent to which the mere use of an algorithm or a platform that uses technology to set prices and other competitively sensitive variables can lead to liability or even exposure. Here's where we are. I think it's a little different than the prior discussion in the sense that the technology of ChatGPT was more or less an event, whereas algorithmic pricing, or the use of technology as opposed to human intervention to set prices and to make other business decisions, is not new. This has been around for many years. However many years you've been buying on Amazon, in all likelihood, you've been seeing a price that was not generated by a human being. You're seeing a price that, in many cases, changes thousands of times a day. And that's true on many other platforms as well. And so this has been more of a slow burn of an issue that's now come to the surface. And we don't just see it in the tech industry. We see it in airlines. We see it in the agriculture space. There are several cases being brought by the Department of Justice. And what's really interesting, and I'm not going to take one side of the debate or the other because we're involved in cases on behalf of clients, but what's really interesting here is it's challenging, I think, our traditional notions of agency. And this feeds into other legal realms. And we have a long tradition under the Sherman Act, and there are many, many cases that suss out what it means to conspire, what it means to agree with a competitor in a way that's anti-competitive. We also have a long line of cases that determines what types of business practices, particularly the use of technology, is reasonable, the rule of reason. And what we are seeing today is an effort by the agencies and the effort by plaintiffs' attorneys to stretch the bounds, I think, and I'm not suggesting we're on one side of the line or the other, as to what participation in unlawful conduct can be, buying a product, using a technology. At what point does the use of a platform created by somebody else make a firm liable, make a firm a participant in something that is unlawful, that leads to higher prices or to other bad outcomes? And I think we're now at the point legally where we see a bunch of cases wending their way through the courts. The courts and the agencies, let's just say, are sort of duking it out. I think we're seeing different opinions on this. We'll see if these issues rise to the level of the Supreme Court. But that's where I see a big new realm of antitrust discussion coming forth.
Yeah, sure. I think AI improve even these algorithmic collusions that we've seen for years. Like it's near perfection, so that's interesting.
It makes it much more efficient.
Right.
And it also makes it more of a risk in the sense that when one creates AI, one might not know what roads it might go down, particularly when it's engaging in price signaling and other things.
I mean, Adam, I just wanted to sort of separate two really important points that you bring up. I mean, one is, sort of the evidence over the last decade or so that when you're using machine learning systems and they're engaged in a competitive sort of like a competitive interaction setting, that the outcomes may appear to sort of from the outside to seem collusive, but the algorithms may not be explicitly colluding in a way that, sort of conforms to the legal definition of collusion, right? And I've done some academic research on this myself, and I think it's very clear that, with no knowledge, like you can have a simple reinforcement learning system, like a bandit learner, that has no knowledge that it is in a competitive environment at all, that it is simply sort of like, trying something, getting a response, updating its actions. It has no knowledge that a competitor exists. It has no knowledge of any of the actions that its competitors is taking. There's still a pretty broad range of settings under which it will find the collusive, what one might think of as the collusive outcome, the outcome involving higher prices. And I mean, to your point, the fact that, in like the real estate rental sector, for example, a number of companies may be using the same algorithm, makes it more likely that this kind of outcome would be observed. But I think the other point that you raised that is sort of so fascinating and makes me think of a discussion in the self-driving or autonomous vehicle sort of sector a few years ago has to do with AI agents that have some autonomy, and what is the extent to which an entity that is using, like if something happens when you have an autonomous agent, who is liable? I think in the self-driving car setting, it had to do with, you can imagine, right? I mean, there's the manufacturer of the car, the person who owns the car, the person who created the autonomous driving, the person who provided the training data for it, and if there's an accident, who's liable? But I feel like we're entering a realm now where, as AI agents sort of enter the world more broadly, there's going to be like a tremendous amount of complexity.
I can totally.
Really quick on this. I think, so I've been involved in some of these cases that Adam mentioned, and unfortunately on the winning side of two of them. But I think what was evocative to me about that experience that I think is worth remembering at an event like this is that the case, this sort of battle between the regulators and the courts and litigants, which is ongoing. What's striking about it is that I think it applies like 100-year-old law. And I think that it's useful to keep in mind as we sit sort of in a setting like this where, Katrina's ahead of 99.9% of people about AI.
Bar
right?
is low.
Yeah,
very low.
In my case, very low. But I think, there's a temptation to say that because the technology that's coming out is so extraordinary in so many ways and has the potential to change so many things. I think it's also worth keeping in mind, though, that not every situation involving this technology requires some sort of new regulatory apparatus. I mean, some might, right? But in this particular instantiation of it, I think the courts, and even if you look at, say, what the regulators are saying in this space, I don't think that they're actually saying that the legal framework that's been applied has to change. I think they just have a different view than some of the other litigants about what that framework is. So I think that's a useful reminder that as we look at the problems of regulation created by this technology, it may not always be the case that we need a new paradigm. It may be that some of the structures we've been using for a very long time actually are quite robust. That may not be the case for in all cases, but it's certainly not the case that they're useful for none of them.
It is true that something that is illegal does not become legal just because you used AI to do it. It's still illegal.
Right. Yeah, and Justin, to your point, Justice Brandeis wrote about this 100 years ago in the American Column case, which was one among the first information sharing cases. And essentially what he said is it's a balancing test. And when there's information sharing among competitors, that can be a common occurrence even way back when without the use of the technology we have today. And it's not always unlawful. Mm-hmm. It is unlawful under certain circumstances. And again, it's the reasonableness test. Is the information sharing reasonable? Did you take reasonable measures to protect against the anti-competitive harms? Now, the law is going to change at the margins to adjust to technology, and it's now far more efficient at getting to either an anti-competitive outcome or a pro-competitive outcome than before. And so there will be adjustments, but it's been there for a long time.
It's a question of evidence as well. Like, how do you demonstrate the anti-competitive intent or outcome, and how do you precisely show the opposite? It's a question of how do you demonstrate it. Amba, do you want to wait on this?
No, I mean, actually, just exactly what you said is that I think some of the heat on the regulatory interventions in the algorithmic pricing space, and also the flip side of this is the kind of algorithmic wages space, which relates to ride-sharing apps and such like, where it's sort of workers on the other side of it are arguing that they feel like there's, they're being squeezed in terms of their wages, and it's being done in an opaque way, is that the regulatory intervention might actually, the thrust of it might actually just be transparency, which seems simple, but for all of the reasons we've just discussed, I think the obscurity or the opacity with a lot of these AI systems, especially the new generation of AI systems, is structural, it's by design. And so challenges like explainability of AI, which we've been grappling with for the last decade, are only getting worse. And I think our perspective as sort of public interest advocates is usually to say, well, that's an industry problem. We can tell you what the consumers want, which is transparency, and the question of how that is figured out and in what terms that can actually be meaningful is a burden that we should kind of put back on companies rather than have to solutionize ourselves.
Related problems with the AI development of apps and precisely this ecosystem that is developing is precisely data and how you scrape data and potential infringement of copyrights or those claims that have been made, sometimes legitimate claims, sometimes the very loose claims. So what is your take of the panelists on these interactions between AI and potential violation of intellectual property right specifically and copyright specifically? Yeah. Do you want to start, Arun? I know you have a lot to say about it.
Well,
So,
yeah, I mean, I guess first, I mean, there are hundreds of cases in the courts right now that, will start to get resolved over time. That will probably sort of give us more concrete sort of precedent-based answers to the question of to what extent can a company use copyrighted information to train a model? I think it's a complex question, right? Because on the one hand, there is the possibility that a generative AI system that is trained on certain works will produce works like what it was trained on. On the other hand, there's it's unclear at this point, the extent to which those new works constitute products in the market of the work that it was trained on, right? I mean, I think this comes down to perceptions of, there have been many studies that show that, people value human-generated music and AI-generated music differently. They think of them as different product categories, not just as if there's a Taylor Swift music-generating machine, people will say, well, if it wasn't generated by Taylor Swift, I don't feel the connection to it. I mean, it's just sort of a bunch of tones and...
That's accurate.
and words. And so...
I'm going to the Taylor Swift concert on Friday.
Okay, well, we are all jealous. but I think that there are a couple of deeper issues that are sort of bubbling under the surface. So I realize I haven't sort of said a lot about, should training an AI model on copyrighted data be considered fair use or not, but I think that that's sort of an open question. I mean, the two sort of issues of the future that I think are going to become really interesting. One has to do with, sort of the ownership over the output of an AI system. If something is generated purely by an AI system, from what I understand right now, and I'm not an IP lawyer, but from what I understand, my reading of the statute is that goes into the public domain if it's generated purely by an AI system. And I could imagine a future in which we are generating or sort of creating some notion of an AI replica of ourselves, we are twinning ourselves. Many of you might have seen Reid Hoffman interacting with his digital twin. I have colleagues who are replicating Ashwath Damodaran, who's sort of the valuation expert, into an AI system. I mean, we've all, to varying degrees, sort of replicated a little bit of our own capabilities in AI systems, and this will become increasingly common, right? And so, if we don't have a system in which you can assert ownership over something that was generated by your AI replica, I think that we're severely limiting the extent to which you can, as an individual, get value from these systems. Right? I mean, if I want to delegate to my AI twin and then have it sort of do some thing that is essentially using my human capital, it would be nice to be able to have clarity on sort of what kind of ownership claim I can make on that. I think the second issue, which also has to do with digital twins, has to do with the extent to which you have control over the creation of a replica of yourself. Historically, like if I work for a company, it is, or at least in the United States, my expectation is that the work that I generate is owned by the company, but my human capital is mine, right? If I leave the company, I leave with my human capital. Now, it's unclear as we start to embed our, once you have a technology that can learn how I do something based on what I've done, can replicate some aspects of my productive process based on examples of it, that line between, I guess, style and, artistic style, which generally isn't protected, and work starts to blur. The line between idea and expression starts to blur. And, I don't think that this is just an issue that writers and musicians and artists should worry about. I think a talented business development executive may have a certain pattern that can be learned by a system, and then when the executive leaves the company, that talent is left behind. I've seen reports of extremely skilled foundry workers who are sort of critical to a manufacturing operation. Their movements are being recorded to be replicated in a robotic system. You can imagine, cameras being put on the wrists of surgeons to sort of replicate their surgical ability. And, I'm not saying that there's a clear answer to the question of, I'm actually saying that there isn't a clear answer to the question of where do the boundaries around one's human capital end? Because on the one hand, you want to own your human capital. On the other hand, any system, whether it's a robotic system or a generative AI system that is being created using examples of your work, isn't being created exclusively using those examples, right? There's a whole bunch of other technological innovation that is embedded in the general purpose generative AI system that allows it to write like you or create music like you. And so the boundaries aren't clear, but I feel like our identity as humans is often tied to our productive capability. Our incentives to invest in human capital are tied to our ability to sort of in some ways exclusively get returns from them. So I feel that this is a regulatory issue that is sort of under the radar at this point, but will sort of bubble up in the future as we start to twin people more.
Yeah, we discussed the fact that we need compute and we need data to develop AI. And of course, if all these data sets are not available or everything is proprietary, that creates a lot of barriers to entry for new entrants. But at the same time, you want the innovation brands. You want people to invent, innovate, and be paid for their creation, for the content. So, perhaps, Ambadou, what is the good approach to resolve these kind of tensions between the merits and the need to reward content creation, even if it's powered by AI, but at the same time keeping the openness of the data sets and the availability of data so that you can train?
Yeah, I mean, I think that when the first generation or the more recent generation of generative AI models came out on the market, there was this sort of widespread and intuitive idea that because these models were trained on just the internet, publicly available, for the most part, publicly available data on the internet, that sort of data wasn't a very significant barrier to entry, and data's everywhere, and there'll always be more. But I think what has become clear is that quality data, and particularly as we've been talking about more sort of specialized and narrower models, everything is going to hinge on the quality of the data sets, the way in which they're structured. And so we've seen, I think, around, for example, the OpenAI Axel Springer and some of these other content deals that were inked, there were concerns, two kinds of concerns. One, from the broader community of other AI model developers that are worried that these deals that are being inked behind closed doors are being set at such a high or potentially overvalued, or that's obviously in the eye of the beholder, but at a level that therefore acts as a competitive disadvantage. On the other hand, we've also been hearing coming from many of the. It's interesting because in my career, and I've worked on copyright policy for maybe 2 decades ago. Copyright wasn't the tool for the people. It was very much assumed to be a tool that essentially allows for value distribution or value accumulation among copyright owners, which is often distinct from who you might associate to be the creator, right? But I think what's really interesting is that that's sort of surfacing up again, which is that the creative community, and we've seen this in the writer strikes, et cetera, are sort of mobilizing on this question of copyright, not because necessarily these content deals that are being inked will mean that the value flows to the creators themselves. In most cases, I would say that's not the case. But it seems as if copyright is that most potent, or maybe even the last frontier where that conversation about value distribution from AI can be had. So there's clearly this like new digital infrastructure is being created based on people's creative and other kinds of work. How will the spoils of this market be distributed? And I think copyright will be one of the most important frontiers where that is fought. And one of the fault lines will be, I think, even within copyright owners, how the bargaining happens between workers and owners.
Yeah, that's very interesting. Perhaps a few final thoughts before we open to questions. For those questions, I will be very grateful if you can come to the mic in front. That will
bring yourself to the mic.
Bring yourself to the mic, or your AI duplicate comes to the mic. I don't know. So, any final thoughts before we open to the questions? No, let's do it. So, yeah, any questions? Yeah, please set up. Just come to the. Yeah.
Hey, thanks for that discussion. Satya Marar, the Mercatus Center. There's been a lot of talk about private concentrations of power and how that can be misused. We know the biggest concentration of power is the legalized monopoly on violence known as the government. We know that the biggest companies are often quite susceptible to pressure from the government, especially if the government is their client. We know that even social media companies have helped the government flagrantly violate the law through the violating the First Amendment, for example, suppressing speech under pressure from the government. And structural intervention is one of the tools in the toolkit that has been used, against private companies for various good and bad reasons. So, given that situation, my question is, do we need to do something more to limit the extent to which the government, either on its own or through private companies, including those it deals with or those where the government is their client, can violate our rights, surveil citizens, for example? And to what degree can this legitimate concerns about national security be used in a way that will foster that? I mean, I know, for example, one of my concerns is moving towards more of a closed foundation model system due to national security concerns could just make it harder for citizens to check the power of the government when they violate surveillance laws and so on by not being able to fully understand what the government is able to do. Yeah.
Well, very broad questions. Anyone wants to? Katrina or any?
I can start. I mean, I come at the question from a different perspective in that I don't think that government is inherently always rights violating. Though I acknowledge that like governments, like companies, and like all of us do things that we wish they didn't do and need to be held accountable when that happens. One structural point up front is that the barrier to entry to actually even doing business with the government, as I was mentioning earlier, is kind of high. So, I don't know that right now today, all of the AI companies are clamoring to do business with the government. I mean, I actually think that it's really my focus. I don't do sales. I'm not, that's not my role. My focus is on ensuring that the government understands the moment that we're in and has the ability to benefit from the leading edge that we have on this technology in terms of thinking about what it's going to mean in the national security context. Whether they're using our tools for their own business purposes or not is kind of a separate set of issues that aren't really germane to the work that I do. I can't answer all of the points that you raised with any fidelity, but what I can say is that we do a lot inside the company to think about what the usage guardrails are going to be around how we allow our technology to be used, particularly in the defense and intelligence context, which is, I think, probably where you are, and law enforcement context and things like that, most concerned. And that's a process that I'm deeply involved in and have co-led with colleagues from our platform policy team to really identify what I think of as kind of two axes of concern or things that we really need to get right. One of those axes is the severity of the potential harm. Like, what could this technology be being used for? What could the use case be at its most extreme? And is that something that we are comfortable with? If the answer is like technology is going to be used to make unilateral decisions about lethal operations, that's pretty extreme. Definitely not comfortable with it. If it's going to like improve an internal HR system, like way more comfortable. That feels like something that the stakes are lower. On the other axis, it's what the technology is actually reliably ready to do. And there are things, you can imagine things that the technology just isn't ready for. It's not going to reliably perform that function. And that's another dimension of how we think about whether we're going to approve a use case or not. The bottom line is that we have decided in our company, and I think other companies are moving this direction too, to set the bar at defense and intelligence usage pretty high. And the level of scrutiny that we're going to apply to those use cases is going to be higher than for really any other type of use. I think we have put out in our usage policies some on that. I think we're going to put out more publicly in the coming months. I'm expecting later this week for the White House to release its national security memorandum, which will outline how the government plans to set its own boundaries around that. And I will be looking very closely at what they put out. But what I would say is, like, these are very important questions. The good news is we're not there yet. Like, I don't think any of the companies right now are really like deeply entrenched with government yet in these spaces. It's going to happen. These questions are going to need to get resolved, whether it's my company working with them or other companies working with them. The government's going to get access to these tools. And I think, we've got to ask some really hard questions about how they're going to be used.
Yeah. I think what it boils down to, and what I'm hearing from both Arun, from Katrina in her remarks, is that there are a wide range of outcomes here with where the technology goes and where the use case goes in your remarks. And the way I think about it as a lawyer, and I'm sure Justin thinks about it the same way, but I don't want to put words in your mouth, is that do you have the right political and legal operating system in place to deal with these issues, because they're important. Rule of law becomes extremely important. And as we look at competition, we're looking at within nation competition, we're also looking at geopolitical competition. And in geopolitical competition, it's a competition between these different political operating systems, some which rely on more government support, more regulation, more government oversight. Others like ours, I think, rely on less government support and by and large less innovation. And so to me, the question is, are we where we want to be today with a number of players? And I think we do have in this country a number of leading players coming up with the best technology, and as compared to our geopolitical competitors. And so it's not all perfect. It's very messy. But to me, I think as long as we have that rule of law and that political operating system in place.
All right. We're going to take the next question. A few minutes left.
Thanks for the fascinating discussion. My question is about the AI stack. It also takes a lot of water and electricity to run a lot of these data centers that power modern models. And I'm wondering if any of you think we'll get to a place where competition over natural resources is part of the overall competitive landscape in the AI space. Are we going to see multinational tech companies competing with municipalities over access to water and electricity? And is that an antitrust problem or something else?
Well, I don't know the answer to the substantive question of where all of that resource competition is going. But I do think that embedded in your question from an antitrust point of view is something that I think is a little bit unique about the moment that we're in right now, which is the role of, there's a very, throughout the entire discussion and General Nakasone's remarks, it's kind of taken as given that there should be some sort of industrial policy around AI and the infrastructure associated with it, right? And there's a lot of reasons for that, I think, because there's a lot of inputs and there are geopolitical concerns about those inputs and the outputs. But what's really interesting, I think, from a competition point of view is that industrial policy conversation is getting off the ground at the incipiency of these markets. Again, I'm not sure any of us know what the market is, or we haven't been especially precise about it. But it's really rare, I think, from a competition point of view that you have government involvement and kind of an industrial policy framework as the market is growing and taking shape. And I think it creates almost this sort of Heisenberg problem that as the government tries to regulate in this space, it will actually, by sort of observing and trying to regulate or even casting, even sort of looking at things, it will shape, I think, how the markets develop, both from a software point of view, but also I think from the infrastructure point of view. I'm not sure I can think of an example in competition law where that dynamic has been in place. Usually the government's getting involved in a market that's much more mature, or we see some of these things from in markets related to national security technology and things like that. So I think that presents a lot of challenges, maybe opportunities for litigants as well, but some challenges in how to think about markets and barriers and power when government is going to get involved in one way or another in the competitive dynamic. I think it's something a little different.
Sorry, go ahead.
No, I was just going to say, outside of the sort of antitrust space, I think there's also, for political representatives, this is likely to become a problem for their constituency. So we're seeing in Northern Virginia that there have been massive protests around power cuts. I think on the other side, there have been these flashy PR, announcements around data centers being opened up and all of the jobs that will be created. And several months later, people are like, wait, where are the jobs? So I think that in general, this is likely to become a sticking point, which will require a much more persuasive public interest case for why it is that this infrastructure build out needs to happen for AI, because I think there's been a lot of breezy associations, including, I think, as we've discussed today, yes, innovation, yes, public interest, but I think when it's material resources on the line and a broader sustainability question, we need to get much, much sharper on what the public case is for AI to begin with.
I mean, I think a lot of the projections of power use, many of people have seen the Goldman Sachs report that says that 40% of the US's power needs growth is going to sort of come from data centers, sort of assumes the technology is the same. And I don't mean the power production technology, I mean the semiconductor technology. I was in Japan last week and I was hearing about a new chip technology from Docomo that is dramatically reducing the power needs. Now, it won't deliver the same, sort of horsepower as the latest NVIDIA chips. But I think over time, that's not going to be necessary at scale. And so, I'm always a glass half full of the water that you're worrying about kind of guy, who thinks that as our appetite for AI infrastructure grows, the sort of the innovation in power efficient hardware will probably mitigate the problem substantially.
Great. Thank you. Thank you so much. I think we unfortunately have to wrap up. I mean, we could have talked for hours, as you can see. Well, join me in a round of applause for my wonderful panelists and their great insights. We just have 10 minutes break for the coffee break that's going to take place upstairs. Thank you so much.